Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. After a year of hurry up and wait, federal employment agencies are ramping up their level of activity. The Department of Labor and the National Labor Relations Board are rolling out new tools, shifting priorities, and redesigning procedures to keep pace with a rapidly changing employment landscape. This week, we're looking at what's new at these two agencies. DOL rolls out compliance tools. The agency is offering new tools to help employers avoid unintentional violations of federal wage and hour laws. The updated and expanded tools include interactive compliance toolkits for wage calculations, industry-specific guidance, updated fact sheets on overtime, exemptions, and worker classification, and online self-audit checklists. The DOL has also issued a proposed regulation requiring more transparency from pharmacy benefits managers, open for comment now. The regulation would require PBM disclosure of the full range of fees, rebates, and compensation. In addition, the Department of Labor's Employee Benefits Security Administration has announced a major overhaul of its 2026 enforcement priorities. The agency will shift enforcement priorities to cybersecurity, mental health benefit access, protecting benefit distributions, retirement asset protection, surprise billing, and criminal abuse of contributory benefit plans. While not a priority, the agency will still continue to identify fraudulent multiple employer welfare arrangements operators and will reduce its focus on missing retirement plan participants. Employee stock ownership plans are no longer an EPSA priority. The National Labor Relations Board adjusts processes to overcome its backlog. Faced with a significant number of pending cases due to the government shutdown and staffing issues, the NLRB has instituted a new intake procedure for unfair labor practice charges. Charging parties must submit evidence and documentation within 2 weeks of filing a claim to avoid dismissal of the charge. Instead of assigning claims to investigators right away, regional offices will now hold each claim in a queue to allow for the submission of evidence, evaluation of the case, and sufficient agent capacity. While priority cases like potential 10J injunctions will still move faster, this new procedure will likely result in longer wait times for many cases. That's it for this week. Thank you very much for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.